Trial Lawyers University, where the Titans come to train. Produced and powered by LawPods.
All right, we're here with my buddy Randy Sorrels, and Randy was just teaching at what I thought was so far been my favorite conference was TLU Huntington Beach. So how did you like that conference, Randy? Because you get around a lot.
I've been to a lot of conferences, and if there is one better, I can't remember it. Pretty amazing, great venue. Everybody was tight together, family environment, meaning we're all rubbing elbows with each other, and great presenters, just great presenters.
Yeah, I was really happy with, we had 4 lecture tracks and I think 9 workshop tracks, and just the greatest trial lawyers, and then having the lobby lounge with the games and stuff, and the open bar, the DJ just really topped it all off. So but it's next year, so we're going to be back next year in Huntington Beach at the Paseo. That's June 4th through 7th. But we got a conference, we got a big event coming up in Vegas this year, October 16th through 19th. And, we're going to be talking about what you're going to be teaching there. But before we get to that, first, I'd like to, when did you know that, you really knew that you wanted to become a lawyer? How did you know?
Yeah, probably sometime in high school, I took one of those aptitude tests, and they said, don't be a lawyer. And so that was the challenge I needed, because I had seen enough TV shows and it looked interesting, and you get a challenge thrown your way like that, then you take it on.
Well, that's a good, well, if they tell you not to, that's a good reason to become one. You obviously got the right streak, and you have resistance to the power structures, even at a young age.
I would have been a better mathematician according to that.
It sounds a lot boringer than being a trial lawyer, or even any kind of lawyer. So you get this inclination to become a lawyer, and where do you find yourself in law school? Or where'd you go to law school?
Yeah, so I went to undergrad and kind of focused my education that way, because we had a dual major. I went to Houston Christian University, HCU, played soccer there, and got a degree in political science, which is a traditional route. But they gave a second, you had a dual major, was communications, which is just speaking in front of people. And, that's hard for most people, me included. And the more you do it, the better you get. And that was a great training ground. Used my communications a whole lot more than my political science over the years.
Wow. And how do you think being a college athlete has helped you in the courtroom?
Yeah, soccer is a team sport. Everybody's got to do their job. And I was a pretty good soccer player, but I didn't have natural talent. So again, working hard, working as a team, never giving up, going through the painful parts of training, which training is painful, and trying to enjoy the ride, kind of like prepare for trial. Enjoy the ride till you get there, and then the games are just a blast.
Right. Everybody always talks about how much they hate all the preparation, but as soon as it's, the jury walks in, it's like showtime. And now the fun begins, because all that preparation starts to pay off. So you get through college and law school, and you finally, back in those days when you passed the bar, I'm sure it was still an envelope in the mail. So you get that envelope that, gives you the good news. And so tell us about where you start out your career at, and the journey to where you are today.
Well, they'd put telephone lines in Houston by the time I passed, so we actually got a phone call. I started at Fulbright and Jaworski, a big firm, and the firm had someone who would call, because there was a lot of first-year associates, including myself. Fulbright and Jaworski is a big firm, one of the biggest firms, probably was the biggest firm in Texas at the time. And some person calls for all of the first years, and you just want to be on that list of passes and not get that call from the administrator saying, hey, by the way, you did not pass. Luckily, everybody in my class passed.
Wow. And Fulbright Jaworski, were you there at the same time Mark Lanier was there?
Mark was there just a little bit before me and left a little bit before me. But back then, he looked like he had some real potential, according to everyone there. And talk about being prophetic. His potential was far beyond anyone's imagination.
That's for sure. Now, at Fulbright Jaworski, is that mostly a defense firm, or is that a plaintiff's firm?
Yeah, no, it's a big mostly defense work, but commercial litigation, of course, is plaintiff and defense. They, at that time, kept a small docket of Aetna cases. There was a senior partner who was, at that time, Aetna did casualty losses as well. Mostly they're a healthcare provider or insurer. Then they had commercial and personal lines. And I got on that team. That was the biggest break for sure of my start there at Fulbright and Jaworski. And in 3 years, got to try 19 cases, which was pretty unheard of at a big firm because I had bosses who were supportive. Some of my classmates who were from the East Coast schools or top 15 schools, they weren't used to the communications or the mock trial moot court I got at law school. And everybody was said, go knock yourself out, go try some cases.
19 jury trials in 3 years. How many of those were plaintiff and how many were they defense?
Yeah, all defense, 19 defense cases.
And so you do all those trials, and how long do you stay at Fulbright and Jaworski for?
3 years, a great run there, had great bosses, and developed good friends in the insurance business. Still have some of those friends now, run up against them some of the time. Now they're senior claims specialists, vice presidents, and hopefully the claims I bring are in their wheelhouse, meaning 7 figures plus.
And they're recognizing the merits of them and just writing checks and not requiring all this extra trial work since they know you'll go anyways. That's the deal. That's the idea, hopefully.
That's the goal. And they know that, it was within the first 2 months of being licensed, I was trying cases, and they know it's the fun part. They know I enjoy it because they were the client and we just love doing stuff together.
After the 3 years at Fulbright Jaworski, where do you go from there?
Yeah, I clerked at a firm that was considered the oldest plaintiffs firm in Texas, and it had some dwindling of numbers during law school. I got an offer from them, went back to them, and within a couple of years, I had again tried a whole bunch of cases, and they decided to make me partner, and was managing that firm and built it back up. It was really the star-studded firm in the 70s, and then as things happen, people go to make their own fortunes, and things dwindled down, and I brought it back up with diversity, they had no women lawyers, so we brought women on board. We brought people of different cultures, and grew the firm back up and ran it for probably 25 years and was there almost 30 years.
Wow. The name of that firm was?
The old firm was Hill, Brown, Kronzer, Abraham. Hill ended up being Chief Justice of the Texas Supreme Court, Attorney General. Brown ended up being Chief Justice of the Court of Appeals, and Kronzer was the best appellate lawyer in the state. He was most known for the Pennzoil case. He represented Pennzoil with Joe Jamail securing a $10 billion verdict and putting Texaco into bankruptcy.
And so after what you said, 30 years, you were there for 30 years?
30 years.
Wow. And why did so you decide to leave, but tell us about that decision, because that had to be a hard decision to leave such a place that you basically built.
Well, you've of course met my wife, Alex, and we met and ultimately married in 2016. So a second marriage. She was a lawyer, top student at University of Miami undergrad in Florida, University of Miami Law School, top grad, came back, clerked for the Texas Supreme Court, went to work for a big firm. We got married. The big firm life isn't for everybody. It wasn't for her. And ultimately, as she saw how much fun we had doing plaintiff's work, at that point in time, it would not have been fair to bring her on as a partner at the other law firm. And she said, I didn't work this hard to be an associate all my life. And so we started a partnership. It's just going to be the two of us starting in 2021. And we're now getting ready to hire our 25th lawyer coming up this next month. So it's going to be, we're a firm of 25 in a pretty short period of time.
That is a short period of time. I think a lot of it has to do with the case analysis that we did with the Clemens case, because I think that just everybody knew what a great lawyer you were at that point. They're like, we got to join the Sorrels firm after that.
Yeah,
just
Roger
joke.
Roger Clements. No, that's true. So that was right in COVID. Roger Clements' son and godson were beat up in a bar. There was a lot of preventative measures being taken where jurors were picking the jury, and the judges wanted to make sure that there was open access to the courtroom, so they live streamed cases. That case got a lot of notoriety. A lot of people watched it against very good defense lawyers. Roger testified. His one of his best friends, Mike Capel, also a former major league player, testified. $5,000 offer with less than $5,000 in medical bills, and the jury returned a $3.24 million verdict on behalf of our guys. That case is still going on in the open policy or the Stowers case. There's a legal malpractice case that's been filed against the defendant's lawyer who was handling the case. So it's the case that isn't ending anytime soon.
Right. And if anybody ever wants to see that case analysis or any of the case analysis that we've done over the last 3 years or any of the live events that we've done, they are all on TLU On Demand, which also is an app for your phone. And we also collect the pleadings, transcripts, and PowerPoints for all these cases. So it was preserved. And I know, Randy, that's something that you use to help you. Tell us, how do you use TLU On Demand to constantly work on your skills or work on your game?
Yeah. So after that case, it made the papers actually worldwide. And some guy named Dan Ambrose calls me and says, I don't know if you know me or not. I read about your case. We do this case analysis. Would you be interested? I said, sure. I could talk for 30 minutes or so. You said, well, no, it's a 3-hour program. You need to listen to one of these or more than one of these programs. And anybody that knows Dan Ambrose knows he's persistent. He makes you do your homework. So I listened to a few and realized he had the best lawyers in the country speaking. So it was a huge honor. And then I didn't want to let down anybody. So I got super prepared. Alex, my wife, and I did that program. And, what I learned more than anything is listening to the people you have and the breakdown of cases, how generous plaintiffs' lawyers are, which we knew about sharing tips. But you got the best of the best people, and you can listen to it over and over again. You can listen to it at a higher speed, slow it down when you want to take notes. And we've built some incredible master lists of openings, voir dires, closings, and rebuttal at the firm. And we're a much better firm because you called in the spring of 2021. Thank the Lord.
Well, that's very kind of you. And it's been great having you be a contributor, because one of the great blessings of my job is the opportunity to meet, so many great trial lawyers, because there's so many great trial lawyers out there that for one reason or another, nobody's heard of them outside of their little communities, because, because if you don't really work on, the marketing of yourself as much as you work on the trial stuff, you're going to do great stuff. Just not many people are going to know about it. It's just a simple fact of the reality. So I'm glad that that we were able to do this, and that more people were able to learn who you are, and because a great case isn't a great case without a great lawyer on it. It's just a case until somebody takes it over and puts their heart and soul into it. And so you started your own firm. You're up to 25 lawyers now, but you also did a stint as the state bar president. So tell us about your desire to do that, and how that was for you. Because that's such a, it's a lot of work. That's
Right.
a political thing, and you usually don't see plaintiffs' lawyers get involved in, like the ABA. You know what I mean? Like I don't know one plaintiffs' lawyer's ever been to an ABA conference. So tell us about that choice and experience.
Yeah. So one of my senior partners at lawyers for the most part are more introverted than extroverted by nature. They studied a lot. They had to get into law school, so they were in the books a little more than maybe others. I was more that way. One of the senior partners at the first firm, Fulbright and Jaworski, encouraged it. A senior partner at the next firm encouraged it. So I ran for the board of directors of the State Bar of Texas. State Bar is a mandatory bar. Every lawyer in Texas has to be a member of the bar. We're about 112,000 strong now. Ran on the board of directors, did my stint there. all bar associations are looking for diversity, and diversity includes many things, including practice area. So you're right. Not a lot of plaintiffs lawyers get involved in the organized bar more than, we do obviously in the trial lawyers organizations, TTLA in Texas, HTLA in Houston. And got involved, became president of the Houston Bar Association, hadn't been a plaintiff's lawyer in a long time, and then got on the board of directors a second time of the state bar. So it's run by the board, elected by a president in a contested election. A few years later, there was some ruckus or upset going on in the bar, and I was asked to throw my hat in the ring. I said I wouldn't do it a traditional route, went the untraditional route, and was elected by the lawyers in the largest margin of victory in state bar history in the election. Worked our tails off for about 8 or 9 months, talked to a lot of lawyers, talked to a lot of judges, and that helped this growth to 25 as we go in with a little bit of credibility because your name is out there and your reputation's out there and your resume's out there, and you got to be the real deal. You got to keep your word. That's pretty important in our business. And you got to be, a hard worker. So all that kind of exemplifies how I was brought up. My dad was in the military, and that's how you live life.
So when you say the non-traditional route, tell us what you mean by that.
Yeah, the traditional route, the board of directors of the state bar interviews, and they get 2 great candidates, and then they're elected that way. At that time, when I was considering running, it had been kind of the Trump era, which is drain the swamp and throw the bums out. And that had become popular. It happened in the election before mine. That same type of thought process with lawyers in Texas. Most lawyers think that organized bars are big firms, and so the small guys left out, the family law, the criminal bar, the plaintiffs lawyers, the solos were left out. So I didn't want to go that route and be one of the chosen ones. I wanted to go around and get 5,000 signatures, collected 5,000 signatures throughout the state, met a lot of lawyers, listened to a lot of stories. And when we got in, we were able to put some things in place that made the practice of law better for lawyers in Texas. The bar should be for lawyers first. Sure, we want to protect the public, but you got to have good lawyers to do all that public protection and representation. So put lawyers first, and that message resonated with the voters and ultimately through our year.
All right. Now, you've been a lawyer now some 30 plus years. So out of all those years, what would you say is your, I guess, most significant or maybe your proudest accomplishment as a trial lawyer?
Yeah, from the trial court standpoint, after that Clements verdict, we had a very big case to us, to Alex, my wife, and myself. Catastrophically injured man walking on an airport tarmac when he's hit by a fueling company vehicle, suffered a paralysis from the chest down. When they went in to stabilize his spine, he came out with a stroke on the left side of his brain. So he came out with brain impairment, paralysis, no use of his right arm, and knew everything that was going on. So it was a really, the worst hurt person I've ever seen in my life. A terrific Texas-based defense firm, Jackson Walker, developed the case, had a whole lot of lawyers on it. And right after we did the Clements podcast, listening to yours, we picked up some tips. We realized that it was a nuclear verdict defense. We had about 6 months to get ready, and we threw all of our heart and our time, our weekends, our nights into getting ready, going through mock trials, looking at every answer that could be given and how we would go from that answer. So it was the most prepared we ever were. Very low offer at the time, $5 million. That's low, and that for those types of injuries. And just got ready. Then they brought a famed lawyer here in Houston and Texas named Rusty Harden in to try the case. Definitely someone to take serious. Stories were that after cases he tried in the past, jurors would want to get his autograph and take pictures with him. And he's the real deal, not just a show, the real deal, considered one of the best lawyers in Texas. They brought him in to try the case against us. And of course, we had some good luck, and we had a nice verdict there.
And we're going to talk about that verdict in just a minute and the different elements of trial as applied to that verdict. But before we do, I want to talk to you about what you're going to be teaching in Vegas this year, because were you at both the past two Vegas conferences, 21 and 22, or just the second one?
Just the second one, and I was in trial. I actually missed the 21 was because we were trying the cruise case.
Well, that's a good reason.
Yeah, and then we made the 22 probably because we tried the cruise case.
Maybe. We do judge our trial lawyers by the size of their verdicts. Like they say on some of those billboards, size does matter here in the plaintiff's bar. At least at TLU it does. So in Vegas though, we're going to have 8 lecture tracks and maybe about 17 or 18 workshop tracks, and you're going to be presenting on one of those lecture tracks as well. And so tell us, what are you going to be teaching?
Yeah, well, first of all, I get to partner with someone I held the highest respect for, one of those all-stars you have, Dirk Van der Veer. I went and listened to him at Huntington Beach, again, was blown away by his presentation. But what I don't think people appreciate, and I think I'm a pretty good student of the profession. That guy is a better student because he has compiled some of the best of the best in his manifesto, and that's what he calls it. So I have asked to glum on with him. We came up with an idea that we're going to seek opinions on and responses on, and that is when potential jurors, panelists throw out a question to you that might put you on your heels, or the defense lawyers smile about when they ask it, we want to have the best answer available for that. In fact, I heard you talk in Huntington Beach about how to respond to some of those questions that are meant to be zingers by panelists, but we're going to come back and turn it on the defense. So we're going to do that. And then I'm going to talk about cross-examining the defendant driver in that cruise case. We have the transcript. We're going to go through that and break that down. Again, they used a nuclear verdict defense. And for those of you who don't know about nuclear verdicts, it's one of the few books written by defense lawyers that's designed to give the other defense lawyers, an idea how to keep the verdict down. And, I'm going to go back to TLU on demand for that, because you've run some programs on how to get it back up. And
that's true. David Ball and Sean Claggett did a couple programs, I think at least 2, on nuclear verdicts.
Nuclear verdicts really is a must read. It's free. You can get it online free. And then watching those 2 programs is also a must, because some defense lawyer will pull it out. And we heard a little bit of it through the questioning in that case and realized it, and we got ready on that. And again, thanks to Claggett and Ball, we were ready for that. And then the other thing I'm going to talk about is voir dire on a short time frame. I've got to pick a jury next week in a 8-figure case, and the judge told us yesterday, both the defense lawyer and I, 30 minutes for voir dire.
Wow.
And the defense lawyer was the first to respond, Judge, we need at least an hour, and we really need about 2.5 hours. So we're going to try to beg for 45 minutes and hope he gives us those. But we trial lawyers are often put in that situation. The judges will say 30 minutes, 45 minutes. How do you pick a large damage jury in that time? So we're going to do that.
Well, Kurt Zahner did a presentation, I think, in this past Huntington Beach about voir dire in 10 minutes or less, something like that, because that's all he had in his federal court case that he just recently did. So I thought that was pretty insightful, as far as because that's not easy to do. You got to really prepare, just be boom, key questions. Actually, and Harry Plotkin, who's a great trial consultant out of Los Angeles, he is going to be doing a presentation on voir dire in 30 minutes or less. So that's more reasonable, 30 minutes or less. So I did a podcast with him recently. I thought it was really insightful, because it's just picked almost 800 or helped pick 800 juries. So that's a lot of courtroom experience and seeing a lot of stuff. So that's going to be pretty great, because it also in Vegas. So there's, on one of the tracks, Nick Rowley's going to be teaching for 3 days with his Trial by Human and Trial Lawyers for Justice group of trial lawyers. Sean Claggett and his firm are going to be teaching, along with he just published a book called Jury Ball, and he's going to be.
Hold on. Let me give him a plug here.
All right,
There
we
you
go.
Look, I
Yep.
got it signed by Sean himself. There you go.
All right. Well,
And I'm into it. It's a really good read. Really good read. We just did 2 jury studies with Sean on 2 separate cases. Terrific information coming back. And
with
should I
John
say
Campbell.
Sean? It was with John. John is the one who ran it, but
Right.
Sean and John and Alicia are the ones that promoted the book. But John did it on short notice. He was a prince. Gave us great information for this case coming up next week.
That's great. And John will be teaching with Sean
Wow.
on Sean's track. And then Brian Panish and Rahul Ravapudi and the great lawyers from Panish and Ravapudi. That's an impressive firm, because I think they have about 7 lawyers that have 8-figure verdicts, maybe 8. And that's
Well, I can tell you, going to there, both Brian and Rahul are the nicest guys in the world who will talk. Really, I don't feel like I'm anybody, and they are at the top of the game, and they'll take a minute, not more than a minute. They'll take time out with a smile and share. And that's the thing about your organization. I don't think anybody is pretentious there at all.
Yeah, they really, I mean, I didn't know them at all. Like, I didn't even think they would have recognized me if they met me prior to the pandemic. But through the course of that pandemic, I got to know them really well, because, as a firm, they participated, I think, in more webinars than I think. I mean, Sean did like probably 50 of them, but he was the main presenter from his firm, whereas they had Panish, Ravapudi, Rudorfer, Glassman, Lucas, Shea. They had so many different people presenting on various cases and techniques that I just got to know the whole group of people really well. And it's a really solid team, because people always ask me, who's the GOAT? They throw out different names, and they even throw out names like Lanier. And I'm like, because of the size of the verse, I'm like, he's a great lawyer, but in my opinion, he's not the GOAT. And they're like, why? I'm like, well, because Brian Panish tries all kinds of cases, and he's built a team of lawyers that are, a great team that's awesome, and somehow figured out how to keep them all happy, because he kept his team together. It's like you get a championship sports team and it lasts a year because everybody wants to go off to free agency and, be a bid off to the highest bidder and go to a team where they're not going to win, but to just make more money. And, so he's done such a great job of developing talent and developing his team. And, he hired Roger Dodd to basically run everybody through this 2-day cross-examination course. And he studied a lot with Roger, because when I first met him, I was like, Panish, what do you think your strongest skill is? He's like, all of them. And I'm like, okay, of course it's all of them, Brian. But if you had to pick one, he's like, cross-examination. And being that he thought that was his, he's like, I know how to get to the friction. And so the fact that that's his strongest skill, yet he still had the humility to ask Dodd for coaching just to get a little bit better. And sometimes, when he has, presentation to do, he often calls me and he says, hey, let's work on this presentation together because I want to nail it. And, obviously I don't have any verdicts to talk about, but I do know a little bit about presentation. And so his humility and eagerness to learn too also makes him a GOAT, because he's always getting better. He's never satisfied. He's always pushing his team to get better.
Yeah,
So-
he's an athlete, and athletes know that the only way, if you're not getting better, you're getting worse. And he's definitely one of the best. Lanier, who I, personally know and have hung out with, it's hard to say who's the best. Lanier is really good, and I've seen jurors just melt in his hands. What people don't know about Mark is he speaks almost every week in church, and no one that I know of gets an audience of hundreds every week to talk about, and you got to keep it fresh. So he's a great communicator as well. Mitnick is unbelievable. Claggett, Rowley, all those guys have spoken on your group, and you get a little bit of something from everybody and meld it into who your personality is, and hopefully that turns into great results.
Yeah, I'm so grateful to got to know all those people you just mentioned, and so many people that you haven't mentioned, and because there's just so many great lawyers out there doing so much great work and so much innovation that I'm so fortunate that I could get to the opportunity to find them and then give them a little bit of a platform so they can share their knowledge and experience with others. Because, those folks, I know it, I know for me, like I got an email from a guy today from Detroit, where I'm from, and he talked about, a civil rights case that he tried in Detroit, where I used to live, for a guy who got a broken foot against some police department, and he got a $9.5 million verdict. And it was, I think, his first civil rights trial, but he watched a lot of Dale Gallipo and just studied a lot of the stuff. And he had just started, he was in a different career until COVID. And then COVID came along, and he decided, after taking like 15 years off being a lawyer, he wanted to be a lawyer again, and just started watching case analysis and learning, and got all these skills to go out and get this great result. I was so happy. I was talking about the phone earlier too. I was just he's going to do a case analysis. His last name's Elder, and he's going to do a case analysis in the next month. So I'm pretty stoked about that, because it's such a thrill, because I know what it's like to be a winner, and I know what it's like to be a loser, and being a loser, it really sucks when you pour your heart and soul into something and get kicked in the face. So I'm so happy to hear about his result today. But let's talk about trial now, and along those lines, and we're going to talk about the case, the airport case that we just spoke of. But in the 90 days, I know you prepped that case for a long time, but in those last 90 days, that final stretch to trial, tell us some of the things that you were doing to that case to help you really get ready. So you had to stand up in front of that jury, you were comfortable, and you were ready.
Yeah, we're doing it right now for this trial next week. And 90 days is a pretty good time to look at. Make sure you have everybody designated properly. Make sure you have testimony lined up. The before and after witnesses are hugely important nowadays. So we make sure we have those lined up. We make sure we have the doctor's bills, if we're going to submit them, lined up, the doctors lined up, the deposition excerpts, cuts. And we've had an opening statement that we're starting to put together. We're having a closing statement we're putting together. We have a rebuttal we're putting together. And then again, we're pulling from our master list of voir dire, what type of jury are we looking for? That particular case, the airport case, we worked with Robert Hirschhorn, who's a jury consultant here in Texas. And we focus grouped it. He was instrumental in, let's talk about what type of jury we want. He said, do you want a liability jury or do you want a damages jury? And those people, they've seen more juries than any of us are going to see, individually as lawyers. That's just it. And you learn to rely upon them. I'll tell you a story about him in a bit, about a juror that he kept that I would not have kept, and that made it worth everything right there. And making sure all your ducks in a row.
All right. So let's talk now voir dire. What is your mental mindset approach when you're just to voir dire?
Well, if you're going to use big data, which, I encourage you to use on these size cases, then you kind of see what feedback you're getting from your folks. We used a traditional mock jury. I did the defense mock trial. I did the defense side. That was really helpful. Bradley, who was one of our co-counsel on the case, and was really the client contact, he did the plaintiff side. That got us super ready, getting to listen to things. You learn things in those programs. I mentioned this lawyer, Rusty Harden. Rusty was brought in. We talked to some of the mock jurors afterwards, and we said, what if you learned Rusty Harden was defending the case? And we got a surprising yet unsurprising answer, which is, man, he's a badass. But that also means they must have done something wrong. So we decided to do a voir dire on him, a portion of our voir dire on the defense lawyer, to emphasize how he handled high-profile cases, and that elevates the profile. In our mock trial, in that case, we had one of our mock jurors said she had heard this case before, and come to find out, she had sat on the defense mock trial of the case. So that was a break. You got to get breaks to get these. We were able to debrief her and figure out what they were doing and talking about. That was a city of over 4 million people. What are the odds of getting that to happen? And from a voir dire standpoint, we have a master list that we pull from. We are a strike for cause type of firm. We're not necessarily a build a tribe type of firm, but we do try to create some rapport and some connection. And then I kind of crossed the line and went to did some questions that Robert wasn't thrilled with, but that's kind of exposed one of our best jurors. So those are things we look at.
Okay, so but when you first stand up there, what is, in this case, how do you start off to get the rapport going, to get the connection going? Or you just start right with your bias questions?
Yeah, and I'm not a warm and fuzzy guy, but so I got to put a forced yet warm smile. Dan Ambrose talked about that. Put the warm smile on. Yeah.
There you go.
And then you get that going and you talk to them and you're more relaxed, and you're looking for them to answer. And we use PowerPoints. We talk a little bit about what the process is. One of the first questions that we ask on the front end, and we go juror by juror, is besides your faith and your family, what's the most important thing in your life? And I think that's one thing that we start off with. And almost uniformly, every jury that we've picked using that, the majority of the people say your health. And most of our cases are about health. And if health is important to them, it's important to us. That's a theme you have to weave throughout. And again, depending upon the case, we bring other things in. We bring this case next week is a slip case at a grocery store. So we got to talk about, slips and responsibility and video, and there's no surveillance, but surveillance, gaps in treatment, all the things that we identify need to be addressed. We try to address, hopefully in more than 30 minutes. But that's the approach. It's getting people to talk.
You talk about in this airport case, because you were going to be looking for a substantial verdict. So how did you talk about money in that case?
Yeah, so I really thought that was a case we could ask for $1 billion, and I felt that in my heart knowing the damages. But Robert Hirschhorn said, you really don't want to get that high. There's that, of course, there are people who can be so offended that they'll be turned off by a number. And we settled in that I would just say tens of millions of dollars, but that wasn't what we were going to ask for. I knew we weren't going to ask for that in opening. He helped with the jury selection and left it up to us to do the rest. So we talked about tens of millions of dollars in cases like this, and we had to sprinkle in a little bit about the injuries. And that's where we had a juror who said, one of the questions was, have any of you dealt with someone who's a paraplegic? And we had a lady from Great Britain who said her dad was a paraplegic all her life. And that's where Robert earned his money. I would have struck her saying, listen, no one gave her $1 million. And sure enough, he said, keep her, and I'll tell you about the end, what she said at the end of the trial.
All right. And how about, do you do voir dire on the burden of proof or sympathy?
So we've changed that. I did then, but we don't call it burden of proof anymore. We call it standard of proof. We've eliminated burden from our dialogue. It's just a standard. We want to know if people will hold us to that standard or a higher standard. So burden is a word we've eliminated from our dialogue. The defense says it, but we don't. And, I don't know that burden of proof is even in the jury charge anymore. It's, we have to prove our case by a preponderance of the evidence. It doesn't say the plaintiff has the burden of proof by a preponderance of the evidence. So I suggest eliminating the word burden. We talk about that, give a couple of examples, use some pictures or some graphics on how close it can be. And we do that for both liability and damages. A second time around on damages, we talk about tens of millions of dollars. And there's people that will hold you to a higher burden if you're talking about tens of millions of dollars without regard to what the evidence shows.
How about sympathy?
Sympathy is huge. In the short version, you have to cover sympathy, and you start off with just one or 2/10 of your time on sympathy for the plaintiff, but it's got to be sympathy for the defendant. You have got to eliminate any sympathy for the defendant. It's a clinical presentation, and we want a clinical verdict, not based on sympathy at all. And you've got to segregate out the situation. If you're an appraiser, we just had another hurricane come in. So appraisers work in our community of what the damage looks like. In our world, your house, we had a freeze a couple of years ago. The outside of the house looked fine, but pipes burst right and left inside of houses. The inside of houses were in shambles. And so we talk about an appraiser. A lot of our cases are herniated disc. How does the appraiser drive up to the curb and look at the house from the curb and say, that's it? Well, people know nowadays from the freeze, you got to go in and look on the inside. We use examples like that from our community.
This, I like that the standard of proof said the burden of proof. That actually makes a lot of sense. I've never heard that before. And the clinical verdict based upon the clinical evidence. I've heard Sean Claggett say that before. Is that,
I will admit that's where I got it. It's a great line, and jurors love
Yeah.
it. And more importantly, when the defense starts to pull out their BS, we say, see, they don't want to talk about the clinical case. They want to throw in other things. And there's one other good voir dire question is, how do you decide cases? Do you decide it on logic? Who decides it on logic, and who decides it on emotion? And the majority of people say logic. So you tie that back in to logical, clinical presentation, clinical verdict.
Do you do anything to practice your voir dire prior to stepping into that courtroom, or you just kind of run it through your head and kind of sequence it, stand up and do it?
Yeah, so I've done enough of those where when I get into a specific area like this slip case, I haven't done a lot of slip cases, significant ones like this. So we definitely have practiced, talk about potential answers that are given. More practice is given to opening statement. I definitely have a way of practicing that.
Okay, well, let's talk about the opening statement. And so before we talk about what you did, how do you practice your opening statement?
I write it up pretty much word for word what I'd like. Take my iPhone out. I dictate it, glancing back and forth what would come natural versus what I've written. And then I listen to it back again and again and again, refine it, dictate it a second time, listen to it again and again and again. So it's not memorized where I'm thinking word for word, but I have a pretty good idea of the concepts. And after hearing it from myself, knowing where I need to affect tone, where I need to have hand movement. And so the practice is myself looking in the mirror, meaning listening to it on my iPhone.
So self-coaching is what you're saying.
Self-coaching, yes. I know, it's, what works for you and where you need to slow down and where you need to speed up, where you need to get low and where you need to get a little more loud.
What is your, for an opening statement, what's your visual strategy approach?
So what we've done is we have a deck of slides that we've used in opening statements, and we keep a master deck. We try to put a little more visuals into it. It's not so much just talking at the jury, although that can be effective, but it's weaving a story together, putting some pictures together. The David Ball approach we typically use, which put the rules up front and talk about the story and talk about, how we back up our story, talk about things we did before trial, meaning, look at some of the defense issues and end up with, telling the jury what the case is worth. That's an evolution right there, by the way. I think people say ending up with an ask. And I think you had Nick Rowley say,
Yep.
Don't ask.
We don't ask, we tell.
We tell. And it's pretty convincing. You hear him say it. I think the same thing with Nick, and I listened to his program in Huntington Beach and we had a jury, so I went and volunteered to sit on his jury. And, he's someone that you just want to like. And that's not easy for everybody. I'm not that person. And then Gary went right after that and said, I can't do that. And it was very true. You got to go who your personality is, but he can, in a gentle way, say, this is what the case is worth. And, people listen.
In your opening statement, did you tell the jury the number that you thought the case was worth in the opening?
Yeah, in the end, I said, here's what we are in the medical bills. Here's where we are in the past. Here's what he's lost number-wise, and where's what we need in the future for his medical care. And I think people listen. That case was live streamed also, and a lot of people watched that. That was super helpful for us because Rusty Hard, this lawyer, is famous. I really think people wanted to see him, and in fact, that kind of worked against him at voir dire. They had 14 lawyers there on their side, and all of them wanted to see him do a jury selection, and it was just me and my wife and Robert. And so, the David versus Goliath look was definitely there from the start, and nothing says big cases more than 14 lawyers, on one side of the room. So we said in the end, you're going to understand this, what this number sounds like a lot, but in the end it's not. it's 385 million. People who watched said, you added those up wrong. And I knew it as soon as I said 385 million. I knew I did add it up wrong, but in the end, jury was pretty darn close to it.
They figured it out. It was only 355 million.
Yeah,
or something like
352.7.
All right. They got close. They were close. They were listening. How about, your client, as you told us, suffered catastrophic injuries in this case. So how much do you talk about, in this case and in general, your plaintiff's injuries and how it's affected their life in the opening statement?
Yeah, so we use it a lot. We talk a lot. We use this iceberg, which you've seen me use in some of your programs, on how the damages are affected. I did watch a Mark Lanier video the other day, and he used the road of life, and he put people bogged down in a swamp, and he used kind of a similar way to talk about it. Our list was long, and most importantly, it was agreed upon by almost every defense lawyer there was. So we probably had 30 ways in which his life was affected, and every defense expert, I said defense lawyer, every defense expert agreed with each of those elements. And so it was very effective. It wasn't, they couldn't say a single thing. We didn't stretch anything, of course. And so we used the iceberg, and then we weaved the damages and liability throughout the trial, using before and after witnesses, and that was effective. My wife, I have to give her credit, she put the damages together, the damages witnesses, and in the end, she's the one who, they ultimately offered $40 million during trial, and that's a lot. That's not a small amount of money. And so we talked about it. The jury had been out a day, as a Friday, and they left for the weekend. It's a lot to think about. A lot of things can happen. And one important person said they're talking about comparative fault. They're going to put a lot of fault on you. The defense argued to give us $24 million and put 50% on us. That's a $12 million return. And we said no percent on us. And we said between 350 and 800 million. And, one group says they're talking liability, you're going to get hammered. The other group said they got the calculator out, they just need a bigger calculator. So you don't know, you don't know. And my wife said, we won every witness, we won every day. I got to think that we're going to win this case. We'll beat 40 million.
That takes a lot of courage.
It does.
A lot of courage. Because would that have been the biggest result of your career at that point, the 40 million? Because that's a pretty big result.
No, that's a big, no. Yeah, the answer is yes.
Okay. Because it takes a lot of courage to, but be like, how do you get a $352 million verdict? Turn down 40 million.
Yeah.
I hear Rex say all the time, how do you get a $25 million verdict? You got to turn down 15.
That's
20.
true. Yep.
Because it's easy to take the money, and it's easy to people to have your client take the money is really, to convince them to take the money. You had a video of the incident in that case. And so did you play that video in your opening, or did you save that for the evidence?
We did, but we did some inoculation first because the focus group, some of the focus jurors thought it helped the defendants a little bit more. So we had to do the whole setup before we finally showed it. And then they showed it over and over and over again, breaking it down frame by frame. So I think their focus group was similar to some of ours, and they thought that it would ultimately help them. But we had a couple of tricks up our sleeve, and they did not realize in the end how the video was going to hurt them. And the jurors ultimately, because we used a few of those tricks, said the video was super helpful for you, that their story was not believable, and came out pretty good on it.
Yes. So let's talk about your philosophy on, witness sequencing and order of proof. Who'd you start out with in this case, and why?
Yeah, so we started off with the corporate rep. Our judge threw us a curveball. We took a great deposition of a corporate rep, got tons of great admissions on. We knew it could not get any better than it was. And the judge said, by the way, you're welcome. We're going to play him by video deposition. They said, well, Judge, he's going to be live. That obviously means they're going to get him better prepared. They got a new lawyer. And we fought over that. And the judge says, okay, you can call him Randy by video deposition, but they get to call him live, and you can't cross-examine him. And I said, well, I don't know. How's that fair? They get to call him live. I can't cross-examine him. So we gave up on that. And as it turns out, he was better for us live than he was on video. So much so that we got him to agreeing to, and as he should have, everything under the sun. The defense lawyer came back and said, Mr. Smith, you seem like a pretty likable person. Yes, I am. And you basically said, you pretty much agree with what anybody says. Is that right? They're trying to say whatever I'd say you'd agree with. And it came out, it didn't go well. So that you start strong, obviously, hit him with a punch and punch him a few times the first couple of days, and then start to work in your damages. We had a day in the life video, and we had it ultimately narrated by his healthcare providers, and we broke it up in sequences so someone's not looking at 8 hours of video straight. And that was very effective.
Why did you start? You started with the corporate rep, but why?
Because he gave up a ton of admissions on the violations by the driver. We got ahead of him on the nuclear verdict defense. The fact that they disciplined the driver, that came out, how he violated the rules. And ultimately, we used a grading system, grading grading system for him, and that was effective as well.
When you say grading system, what does that mean?
Yeah, so we developed checklists for every witness and used little dots on how you come out. Do you agree or disagree with this statement? Ultimately, we got the safety supervisor to give him a grade on his driving because they wanted to try to say he didn't do anything wrong. So we pinned him down, and the safety supervisor finally gave him a D, like dog. And within about 30 minutes, we turned that into an F. Now, that means the driver's got to come up at some point in time. He's sitting there in the courtroom listening to all this. We said, okay, you heard your safety supervisor give you an F. How do you grade yourself? That's a pretty tough answer to give when you've heard your own company talking bad about you, and it's a no-win situation. He gave himself a B, like boy.
So you said you put up the damages first. Your before and after witnesses, how did you pick the before and after witnesses for this case, and where'd you put them in the sequencing?
We sprinkled them throughout because we didn't want anybody to forget who he was and what the case was about. The case could have taken focus. Allied Aviation is a fueling company. They drive around with basically time bombs in their trucks. This was a pickup truck, but we talked about the fact that they would have hit a plane, with fuel in it, that type of thing. So you can get the focus on the defendant a little bit too much, and you got to balance and, as close to 50-50 as you can on liability and damages. But this was more like 60-40, 60 on liability, 40 on damages.
All right. Now let's move on. Now, how many did you call many of the defenses other than the defendant witnesses in your case in chief?
Called 4 defense witnesses, the corporate rep, the safety supervisor, his supervisor, and then the driver itself. Used no liability experts. I'm not someone, if it's possible to get a case through without experts, that's our goal from a liability standpoint.
Okay, so you had no liability experts.
Right.
Got it. Because, if you set it up right, then liability, I'm guessing, should be the logical conclusion. Should be common sense that they're at fault.
Well, that's why the corporate rep had to say that he violated the policy and he hit our guy, and they agreed fault.
Let's talk about cross-examination now. What kinds of things, obviously it all starts with your depositions before you can really get into cross. So what kinds of things do you do in your depositions to set up your cross-examination?
We did it by topics. We had a topic notebook, and we asked similar questions from an open-ended standpoint. We didn't try to force anybody to say anything because most of the things we asked were logical. We're going to get logical answers like, you shouldn't drive off the road on an airport tarmac. It's a pretty good logical answer. You got to be on the lookout for pedestrians because they're all over the tarmac. You got to come to a stop when there's a plane that's backing away from a terminal. And so anybody who's going to take a non-logical approach, that's just a gift. So either they all agree, or if they decide to disagree, then you're turning 3 or 4 witnesses against them.
All right. And so then, but you get them set up in the depots, and as far as like, because a lot of people, across, like I like to get in, get out, or, I use a lot of visuals or any, stuff that you think you do that you've developed through cross that you think really makes you more effective in it?
Yeah, you want it in Texas, in state court, you sit to examine witnesses, and the judges prefer to keep you in that situation. So you've got to find excuses to get up and walk around. So you've got to use boards. You got to get up to the TV screen. You got to approach the witness with documents. You got to keep moving to make sure it's not like you can't stand over the witness. You can't just stand in the well of the court and question. So the idea is to get up and keep moving around a little bit. In that case there, because of the way it was set up, this was again a COVID error type of jury. The jury sat where the observers, the audience would sit, and the witness was placed in the jury box. So the jury was spread out, 5 or 6 feet apart from each other. So it made it even more difficult. You have the judge to the left, the witness in the jury box, and the jury to your right, where the audience sits.
Were you wearing a mask during this trial?
You did have to wear a mask during your examination, but the rest of the time that you did.
Okay, so at least I got to see your face and read your face while you were talking and crossing.
Right.
Right. So now, closing argument. When do you start preparing? Well, when did you start preparing this closing argument?
Well, this one, we knew we had to get extra prepared on just because of the quality of the defense team, the numbers of the defense team. Any type of audio pedestrian case too, you got to be worried about comparative fault on the pedestrian. There are some jurors and you do it in voir dire, that say that the pedestrian must share some amount of fault. So we started long before this. Again, you're talking, we had a heavy docket then. It was a much smaller firm. Nights and weekends getting these things ready, practicing them, and going through the process. I've learned a few things though on TLU that I think has gotten us better now, and I'd say what we do now is even better than then.
And what is that?
Well, so Keith Mitnick talks about these note cards. It's a great way to shuffle and reorganize and prioritize what you need to argue in closing and adding to that. And the other thing is we make a list of topics on closing of all the things we cover, and get that list as we listen to the defense lawyers and check off the ones they talk about. And then we have, of course, the list they didn't talk about. And that's an easy fodder, which is, they didn't talk about this issue. The reason they didn't is because they can't, or they're wrong. And you have 5 or 6 issues. He didn't address this issue, or she didn't address that issue. And so you can anticipate what their arguments can be to some extent, but they're disorganized, like maybe we are on rebuttal. They're disorganized on their closing because they're trying to juggle what we say in our closing with what they thought they wanted to say. And in rebuttal, so many times we're disorganized. And I think Mitnick's organization method is a superior one.
What do you do, in your closing? How do you do your jury empowerment?
Well, there's one time in the people's lives, the plaintiffs, that this is going to affect them. And from an individual case standpoint, obviously you talk about this is it. There's one time. This is, a jury for now and forever. And of course, there's the other part is how much power you hold in that instance to tell a company, we're not going to put this in the discount bin, and we're going to, make sure that the plaintiff is fully and adequately and fairly, and there's a story behind that, fairly and reasonably compensated. And it's in relationship to the extent of the injuries, and the conduct of the defendant too plays a role in that. So 2 parts: final judgment for the plaintiff, an opportunity for 12 people to make a difference in society.
You said something about, we're going to talk about that in a second. So what was that?
Well, you talking about in closing argument?
Right. You just mentioned something that I had a mind glitch, but I can't remember.
I did say, I don't remember what was on, but I'll tell you that in closing, they made a mistake. Well, let me tell you this: there weren't many mistakes made by the defense. Mr. Cruz is actually Filipino. It sounds Hispanic. He's Filipino. His wife was also Filipino. She was a nurse by training, and while workers' comp covered his injuries, they covered the bare minimum. So she really had to sacrifice herself. We had pictures of her before, like you'd imagine, with him and after. And I remember at one point she was there. I said, you can see in the short period of time how much she's aged. 3 women shook their head like, yes, she has aged. And we talked about that. We talked about how this amount of money they had. There's a wife had a consortium claim, and the kids had parental consortium. One was age 20, one was age 16. So let's go back to that juror that Robert Hirschhorn said to keep, the lady from Great Britain. The judge allowed people to ask questions, allowed jurors to ask questions through written notes. The same person asked a whole lot of questions. We didn't know who it was. At the conclusion, after the jury returned their verdict, she said, I took 2 full pages of, 2 full legal notepads full of notes. I dreamed about this case at night. I thought about it. And when it came time, remember her dad was a paraplegic. When it came time to award the kids money, I made sure those kids were given $20 million each, because no one knows what they're going to have to go through the rest of their life other than me. As an aside, earlier this year, I don't know who put it together. The state bar found jurors who sat on big verdict cases. One of our lawyers just went to see it, not knowing, and 2 of our jurors on that case, this was, a couple of years later, were on that panel. And it was relayed to me that one of the jurors, of course I wasn't there, broke down in tears talking about this case. I still think about it every week, and just cried for the family and the case, and said something they're never going to forget the rest of their life. So, these things have an impact on jurors too. It's not like they just go home the next day and go about their business. I mentioned, going back to the story, wife's on the stand. The defense lawyer says, you're not entitled to the very best care. You're entitled to what's reasonable care. And, I thought that was a mistake, because everybody wants for their loved one the very best care. But the jury charge says what's fair and reasonable. So we turned that on him during redirect and said, well, ma'am, it's not just what's reasonable, it's what's fair and reasonable. And she agreed. And so we argued in the end, what was fair and reasonable was between $350 and $800 million.
How'd you articulate that, though? Because those are some big numbers. So I don't think we're doing per diems with numbers like that. So,
yeah, well, so we did a reverse per diem on that. We had gotten prepared on the number of hours left in Mr. Cruz's life. It had a significant life expectancy. So we knew the number of hours. They argued for $24 million, which sounds like a lot of money, unless you figure out how much it is per hour, and it's pennies. And no one would trade these injuries for the type of dollars they're talking about per hour, $5 an hour. One was $1.50 an hour for like disfigurement or impairment. It was just outrageous why the numbers were just grossly inadequate. And so we did a reverse per diem because we were prepared. The judge gave us a break between the defense closing and our rebuttal. We did the calculations based on that. We had people in the audience ready with calculators. We put up the numbers so they could see that their numbers were just unreasonably low, and really an insult to slap in the face. So that's how you talk about it. You can use a reverse per diem.
Panish often talks about the reverse per diem. I don't know if you got it from Panish or you came from someplace else or on your own, but that's what I've heard from the reverse per diem.
Very little on my own. It probably was from Panish.
Why do it on your own? All these people are sharing all their ideas. It's it's like they merge together to become our own, but they all come from someplace else.
If I can give credit, I will. Panish told me he stuck his head in on the Huntington Beach thing, and I said, well, someone gave me the idea for this slide. He pulls me after and goes, hey, Randy, that was me. I'm the one who came up with it. I believe him too. I'm sure he's true. I said, well, good. Well, I want to thank you.
That's funny because my buddy Jason Wechter just got like a $28 million verdict on a motorcycle case. It was his first 8-figure verdict. I was so happy for him because I went to high school with him, and he presented in Huntington Beach on that, and he had some slide that he had gotten from Panish and adjusted a little bit, and they discussed it. So that's why I love Panish. He's always in there learning. He's like, when he shares, he's like, "Hey, I'm glad you liked it. Glad you used it. That's great. That's great." And then as far as I think you might talk a little bit about the rebuttal part. But on this case, so the defense argued for $24 million and 50-50 fault. But did you get any fault on your client?
Yeah, zero fault on our client. Zero fault. It was a 11-1 verdict, though, and the one wanted to put fault on and probably keep the numbers down. I think the other 11 just ignored her at some point in time. But I'm going to tell you, she smiled at me every day. I told my wife, she's with us, we got her, and I was wrong. You can't read jurors. Don't let anybody tell you can read them.
It's hard. It's definitely hard. But as far as rebuttal, I think, because you mentioned the note card, so I think that was part of, that's what Mitnick talks about, rebuttal. But do you prepare your rebuttal before you walk into that courtroom?
Absolutely. Absolutely. You prepare it and practice it, and then you adjust. And that's where, a little bit of practice. You're doing this a while, things slow down a little bit. You got a good sense of time. You can keep one eye on the clock and one eye on what you need to cover. And, it's the time where you got to shine and bring it home and provide those jurors that are on your side the ammunition to persuade those dissenters from voting too strongly against you or maybe coming to your side.
All right, Randy. Well, I think that gets us to the end of our discussion here. And I really look forward to seeing you in a few more months. And if anybody's interested, in coming to TLU Live, which, we just got the greatest lineup of so many just fantastic trial lawyers that are lecturing and doing demonstrations, and there's going to be workshops, and, there's things to do beforehand. Sean Claggett Sykes is doing their second annual golf outing at Bally High. Kurt Zander's taking a bunch of people out to go ride dune buggies and ATVs out in the desert. And Nick Rowley's taking a group to go out and do some yoga and hiking out in Red Rock Canyons on the 16th. And so the website is, triallawyeruniversity.com. That's where you can find everything, the TLU On Demand, the different conferences, the Huntington Beach Conference, anything you're looking for. Randy, if people want to get a hold of you, how can they do that?
Yeah, and I'd love for them to, because what we're looking for is the tough questions. I think when I saw you speak in Huntington Beach, I think the question that was approached was something like, "Hey, why should we give someone this much money?" And you had a great answer for that in our justice system, and we're looking for tough questions and great answers. So if you have them, send them to me by email, which is Randy, RANDY, at Sorrels Law, SORRELS Law, LAW.com, or call my cell phone, which is 713-582-8005. Dirk and I would love to hear what you all think are tough questions that panelists ask, and even better answers.
All right. And my email is dan@triallawyeruniversity.com. My cell phone's 248-808-3130. TLU Live is going to be at Caesar's Palace in Las Vegas, and we got a room block, but every day it's shrinking a little bit, thank God, because people are signing up. So if you want to, it's a great rate. It's only $200 a night at Caesar's, and that's a really, it's a real nice hotel right in the Strip. They just redid the convention area, so it's going to be really fantastic. I was just there last week for the National Bar Association. So that was because that was a new experience for me, because it's the Black Bar Association of all types of practices, but you go to an event like that and you kind of get an idea what it's like to be a minority, because you look there and people are looking at you like, "Hey, what are you doing here?" And I'm like, just exhibiting and trying to meet some people. But I met some really great lawyers there. So
you saw my buddy Dominique Calhoun. He just finished up last week. He was the president.
That's who invited me, because he came by. Did you see him in Huntington Beach?
Of course I saw him. We're buddies. We work cases together. He's president of the organization, and he's a great guy.
Yeah, that's why I got there. He's like, "You got to come to, because he's like, you got to come check us out, and and I want you to help just develop some curriculum and for us, so we can constantly keep improving." So that was great. So,
yeah, terrific.
Well, thanks, Randy. Appreciate it, and I'll see you in Vegas.
Thanks, Dan. Thanks for everything you do for making our profession a better profession and arming lawyers and helping. In the end, we're trying to help people who are at their worst times in life. So you've affected a lot of people.
Thank you.
Ready to train with the Titans and set records with your verdicts? Register for our live conferences and boot camps at triallawyersuniversity.com. Start getting your reps in before the big event by going to tluondemand.com to gain instant access to live lectures, case analysis, and skills training videos from the trial lawyer champions you love and respect, as well as pleadings, transcripts, PowerPoints, and notes for a roadmap to victory. Join the group that continues to get extraordinary results. Trial Lawyers University, produced and powered by LawPods.